Friends, let's see some more legal maxims in this episode. Now, first is injure non remota causa sed proxima spectator, which means in law, the immediate and the remote cause of any event is to be regarded. For example, in law of contract, no compensation can be recovered for any remote or indirect loss or damage sustained due to breach of contract. Thus, A can claim from B the amount of debt owed by B along with interest, but not the amount of profit he could have or would have earned if he had invested that amount in stocks had B paid it in time. So thus, the remote cause is not to be regarded, but the immediate cause is to be regarded in the law. Second is ignorantia facti exucast. That means ignorantia juris non exequat, which means that ignorance of fact is excusable, but ignorance of law is not excusable. Thus, you cannot give a reason that I was not aware of the law of the land. Every citizen is supposed to know the law of the land. Third is nullus commodum capere protest ex sua injuria propria. No man can take advantage of his own wrong. This is called doctrine of estoppel. For example, if a owner of goods A gives impression to world that B is his authorized agent, when B sells the goods to C, then later on A cannot dishonor the sale taking a stand that B was not his agent. So once he has said and given an impression that B is agent, then he has to stand by it. Fourth is nemo debet bis vexari pro na iti idem cavsa, meaning a man shall not be twice vexed for one and the same crime. This we have seen in the earlier episode, that is protection against the double jeopardy rule, and also by constitution. So no man can be sentenced twice for the same sentence, for the same cause again. Now next is acta exteriora indicant interioria spectra, means acts indicate the intention. It is said that in some cases the law judges the man's previous intentions by his subsequent acts. Next is domus sua quaseque est tucitium regulajum, meaning every man's house is his castle. For example, if thieves come to a man's house to rob or murder him, and he or his servants kill any of them in their self-defense or defense of the house, this will not be called as a crime. Next is nemo est heres viventis, meaning no one can be an heir during the life of his ancestor. Now it is understood that no inheritance can vest till the ancestor is dead. Thus, till the death of the ancestor, the son or daughter can be only an heir apparent or heir presumptive, and they cannot claim the right on property until the death of the father. Next is leges posterius prioris contrarius abrogant, meaning latter laws repeal earlier laws which are inconsistent therewith. That means some act is passed by the parliament and president is promulgates it. If earlier laws which were in existence, if they were against this, then they will get, if they are inconsistent, they will get repealed. So they will not be valid once the new law comes into action. Next is nova constitutio futuris forman imponere debet non praetericis, meaning a new law is ought to be prospective and not retrospective in operation. For example, a new legislation is supposed to be coming into action the day it is enacted by President of India, Thus, prima facie, the new act is construed to apply prospectively, that is, to future cases, and not retrospectively to which what has already happened. 10 is next one, noscitur e socials. The meaning is, a meaning of a doubtful word may be ascertained by reference to meaning of words associated with it. A word is known by the company it keeps, it is said. Example, if the statutes made carrying gunpowder in a mine prohibited except in a case or canister, it was held that accused was rightly convicted for carrying it in a linen bag because it was unsafe. Next is expressio unis est exclusio alterius, meaning express mention of one thing implies the exclusion of other. That is, suppose act provides every occupier of land, houses and coal mines are to pay tax. It was held that occupiers of iron mines would not have to pay any tax because specific mention of coal mines is done in the act. Next is vigilantibus non dormitibus jura substitut, means the law assists those who are vigilant and not those who sleep over their rights. A limitation period for each action is an example. You enjoy a right to file a suit only within the limitation period. If you yourself don't bother about it, then law cannot help you. Next is actio personalis moritur cum personia, which means a personal right of action dies with the person. For example, in one landmark case, Orissa High Court held that whatever relief the decree holder had against the father under the law of torts by way of misrepresentation of the fact ended with the death of the father and did not exist against his son. So also, in another case, it was held that the personal representatives of the deceased defendant were liable in so far as they had assets related to contracts of the deceased broken during his lifetime and no more. So if you are holding some assets of the deceased, then you are liable only to that extent and you cannot demand further from the clients. Now for legal information, one can always refer to law reports, magazines and reference to case laws. Now there is a lot of information available on net. In any trial in court, case laws of Supreme Court and High Court play a very important role in strengthening one's case, as it forms precedent, an important source of law along with legislation and custom. We end here with our episodes on legal language and shall start with some next other topic in the next episode, which is going to be Consumer Protection Act. Thank you.